Welcome, everyone, to the Sports Lawyers Association's Sports Shorts. In this week's episode, as it were, our guest is Howard Jacobs, the athlete's lawyer, as his email says, who, among other things, represents athletes in doping cases and other disciplinary matters, but that's a very much a 30,000-foot view. And as we like to start up these events, Howard, tell us a little bit about your practice and how you chose to develop your legal practice in this field.
Sure. So, as you said, I represent athletes. What I generally say is we primarily represent athletes in disciplinary cases. So that's anti-doping, safe sport, other types of misconduct. The other main areas of the practice, we handle some salary arbitrations is a fairly significant part of the practice. We do quite a bit of team selection disputes in the Olympic movement, particularly in the lead up to an Olympics. It's particularly busy this year. So that's probably 90+% of what we do. But the firm is 3 lawyers. Lindsay Brandon and Katie Freeman have both been here for a while, and then we're adding another associate who's taking the bar today, actually, starting the bar. And so I've been doing this for almost 20 years. It's kind of a roundabout way how I got into it. I was actually an admiralty and transportation lawyer for about 10 years. First 10 years of my practice, I didn't do any sports law. I had been an athlete. I ran in college. I was a professional triathlete for the first 2 years of law school, and so my first intro into sports law. Well, when I was in law school, I wanted to be a sports agent like everyone else, and gave up on that before law school ended. But I stayed close to sport. My first cases were in triathlon. I did some work for USA Triathlon for a number of years, and eventually transitioned into representing athletes starting in late 2001, early 2002, in the lead up to the Salt Lake Olympics. Represented an athlete on a doping case. And, I'd always found anti-doping to be a pretty interesting area. I spent some time trying to understand how the tests work, because it seemed to me that would be a pretty important thing to know if you're going to defend athletes in anti-doping. I'm still amazed how many lawyers who either practice in anti-doping or want to don't seem particularly interested in understanding the tests, but I was, and I was able to develop a reputation fairly quickly. There weren't a whole lot of people doing it, particularly on the athlete side. There were there were people that represented the national governing bodies and the anti-doping agencies all the time, and so there were very experienced lawyers on that side. But there were no real experienced lawyers who were focusing on athlete representation. And so I decided pretty early on that in order for it to be fair, because what usually would happen is somebody would test positive, they'd have a family friend that was a lawyer and they'd handle it, and they didn't have a clue what they were doing, and they'd do one case and that'd be it. And so I decided that the athletes deserved somebody that was as experienced as the anti-doping agencies and the international federations, and decided I'd try to make that a focus of my practice. Wasn't really sure. I never expected, honestly, that it would become, like what it did. But I started in anti-doping and then branched out into other areas within the Olympic movement, and then other, outside the Olympic movement, ultimately doing the other things that I mentioned as well. And I've done arbitrations in just about every sports arbitral forum that you can think of. I've done cases, and I've had arbitrations probably in about a dozen different countries, and had arbitrations at the ad hoc at the Olympics and 3 or 4 Olympics over the years, represented over 300 athletes in anti-doping cases, and then probably another 100 plus in other types of cases. So it's now it's almost all we do. I haven't done an admiralty case in probably 6 or 7 years at least.
So no writs of fiducione exponus for you anymore, right?
No more votes for me now.
One of the things that interested me that you pointed out that I think may separate what you do from others is you seem to suggest that knowing the science, knowing the testing data is an important element. And I would think so because what's the measure, nanograms or something when they're talking about these testing? How deep into actually studying the science do you get as preparing for these anti-doping cases?
So I've been doing it a long time, and I mean, I didn't study science in college. I mean, I took meteorology, I think was the only science class I took, but as an athlete, I was kind of interested in how the tests work, and so I just started reading journals, journal articles on chromatography and spectrometry, and really taking every opportunity I could to talk to lab directors and know what I was looking at. And it took a while. I mean, it's complicated stuff, and it changes all the time. And I've gotten to the point, and I think I've been there for a while, where I can look at a test result, I know what I'm looking at, and to me it's important because if you're it's arbitration. You're not going to trial. You're not taking depositions. And so if you don't understand the science, I don't understand how you can effectively cross-examine a lab director who's, top of the field. And I think a lot of people just decide, well, I'm just not going to challenge the science. We'll just fight it on length of sanction. And, that may be how 90% of the cases go, but what do you do in the other 10%? And so I've gotten probably as far as I can without a science background and understanding the tests. I've got experts that I work with that help me as well.
So in these procedures, because I think most of the audience probably isn't really familiar with them, it's an arbitration proceeding, and there must be some evidentiary guidelines that you follow, and I assume you're allowed to bring in your own experts?
You can bring in your own experts. I mean, there are some evidentiary guidelines, but it's arbitration, so the evidentiary guidelines are largely that the rules of evidence don't apply, and so hearsay comes in, and the rules in anti-doping are kind of set up, particularly in the cases where you have a positive test. It's presumed that the test is valid and that the lab followed all the correct procedures. And so from a starting point in an anti-doping case where there's a positive test, all the anti-doping agency basically has to do to satisfy their initial burden is introduce the laboratory documentation, 200 to 300 pages of laboratory documentation. And that's it. And then the burden shifts to the athlete to show, if you're going to challenge it on the science, that they didn't follow the applicable technical guidelines or the scientific documents that govern in these cases. And because it is arbitration, there's no depositions for sure. I mean, you get the laboratory documents. You certainly can and should have them reviewed by a lab expert. And then if there's a scientific challenge to the validity, then you bring in your expert. The other side has usually the lab director, and you put it on and hope the arbitrators understand it and go from there.
One of the things that seems to come up often in these cases where there's been a positive test, not often, but in some of the bigger cases over the last 20 years, is, I don't know what they call it, chain of control or chain of command, dealing with chain of custody. Do you find that to be a common defense, as it were, to a sanction in the cases you've done?
I would say generally no. I mean, of course, it's something that you look at. There's certain things you have to look at. One of them is chain of custody, but I mean, I think I can count on one hand the number of cases that we've prevailed on chain of custody arguments. So, at this point, with WADA having pretty strict guidelines that have to be followed, and the anti-doping organizations are generally going to look at the file before they bring the case. And if there's an obvious chain of custody problem, they may not even bring it. So yeah, you have to look at it, but if you think you're going to win a bunch of cases on chain of custody, you're going to be disappointed.
And so you've talked about WADA, but we also have the US version, USADA. And how do they interact? Are the rules the same? Are they slightly different? And is there forum shopping, or is one a sanction? Whoever sanctions is the party against whom you're essentially arbitrating?
As far as forum, I mean, it's changed a little bit over the years. It used to be with USADA, the U.S. Anti-Doping Agency, that basically anytime you had a U.S. athlete that tested positive or an anti-doping charge was brought against them, it was pretty much always brought by USADA. That's changed over time. So now a number of the international federations, the international sports federations, have set up their own what they call independent agencies and their own arbitration systems. So, you know, in track and field, USADA generally does not handle the cases anymore. So like the Christian Coleman case this year, that was handled by the AIU on behalf of World Athletics. Tennis is the same way. The ITF has their own program. So that's changed over time. But, you know, the rules are generally, as far as the substantive rules, they're all the same. They're all based on the WADA code. And then the procedural rules can differ, you know, as far as how the arbitration is set up and how the proceedings go. And so if you're doing a case before the ITF or World Athletics, it's going to run differently than if you're doing a USADA case, and it's going to have a different arbitrator pool, and you know it's going to be based in Europe, and so you have to understand how that's going to impact how the case goes as well.
So I guess the big issue, and it just come up recently after the US track and field trials, is the definition of a performance enhancing drug. And it would appear that the top 100-meter, female 100-meter runner in the world, who clearly admitted that she smoked weed, but that's classified, I guess, as a performance enhancing drug. Has there been any push on that, given, especially in America and in some other countries, particularly here with legalization and decriminalization of marijuana?
So technically, it's a prohibited list. So and marijuana is actually, under the new code, is characterized as a substance of abuse. And so WADA has finally been kind of dragged in, I think, to viewing this difference between performance enhancing drugs and substances of abuse. Our professional leagues have recognized that difference for many years and actually have different anti-doping programs for substances of abuse versus performance enhancing, and with kind of different goals, right? If it's a performance enhancing substance and it's an NFL case or baseball or basketball case, it's going to be similar. You know, it's going to be sanctioned first. Whereas if it's a substance of abuse in the major professional leagues, it's generally viewed as it's going to be counseling first, with confidentiality and no sanction, because they have unions and the unions care about the players, and so they want to help them. You know, the anti-doping in the WADA world has always viewed it all as sanctions first, and I think largely, you know, not much concern about what happens to an athlete if you ban them. They don't really think about what happens to them after that. And so there has slowly been this recognition with things like marijuana that it should be treated differently. I mean, it's ironic because of all of the publicity around Sha'Carri Richardson's case. You know, it's like, well, why is marijuana banned? Well, marijuana is banned largely because the United States insisted on it back in the late 90s when WADA was being set up. They said, we won't fund it unless marijuana and cocaine are banned. And then there, you know, throughout the 2000s and the 2010s, a lot of the countries, New Zealand and in Europe, were like, why is marijuana banned? Like, we're spending all these resources bringing these marijuana cases. I think at one point New Zealand said half their cases were marijuana, and they were like, this is just a waste of money. And so there was a push to remove it, I think, by some of those countries. I think the US was still no, marijuana has to be banned if you want our money. And so what WADA did initially was kind of clever, because it used to be, and we're going to talk about nanograms now, they actually test down to picograms now, which is a trillionth of a gram. Nanogram is a billionth of a gram. And so it used to be the threshold was 15 nanograms for marijuana. And so you could test, you could smoke on Tuesday and test positive on a Saturday. What WADA did to solve this problem a number of years ago is they raised the threshold quietly from 15 nanograms to 150, so 10-time increase. So they didn't remove it technically, right? But the number of marijuana cases went way down. And there was a period of time where there were basically no marijuana positives or close to none, because in order to test positive at 150, you gotta smoke or eat an edible a lot closer to when you're tested, and it's only banned in competition. So it really cut down on the numbers. And so ultimately athletes figured out, well, okay, if I stop 1 or 2 days before, then I'll be fine. And so then the numbers started creeping up, because then an athlete would be like, oh, I'll stop 2 or 3 days before, and they're just over 150. And so there was like an adaptation period, I think, for the athletes. And ultimately with the new code, what they now say is if it's a substance of abuse like marijuana, it's an automatic 3-month ban. But if you agree to do counseling or some sort of education, it'll be reduced to a month. And that's across the board. You can't argue for anything less, which was the one trade-off for no longer being subject to potentially much higher bans. I think everyone thought, well, that'll work. 1 month's not that bad, right? Unless you test positive at the Olympic trials, then it's really bad. So I do think that ultimately it'll probably come off the list. I don't know how long it'll take. There's no reason for marijuana to be banned. There's never been a performance enhancing reason for marijuana to be banned. I don't think that they should be in the business of being the social police. And it's going to take cases like that to kind of push it over the edge. It'll get there eventually.
So in talking about representing athletes, and I know we've spent a lot of time in the, as we're chatting about the drug world, but there's a lot of other issues that face athletes, and I know you've dealt with a variety of issues. In looking at sort of one of the big issues that's existed over the last several years, USA Gymnastics, and I know that we had during SLA a presentation from what was clearly one side view of USA Gymnastics and the problem. And there were some statements made about safe sport and what it does, but I know you work in that area a lot. And I'd really like you to speak about safe sport and how it integrates into, athlete protection basically.
Yeah, I mean, I think by now most people know that safe sport kind of grew out of the swimming and gymnastics scandals. And essentially, I think the model was, let's look and see what we did in anti-doping. So we'll talk about anti-doping for 30 more seconds. So, it used to be before USADA was created and before WADA was created that every national governing body had to prosecute its own athletes on anti-doping. They were responsible for policing it. And then there was this view, well, that's not right. There's clear conflicts of interest. It's the classic fox guarding the hen house analogy. And so they created this independent agency back 20 years ago, over 20 years ago. And it's definitely independent and it's definitely different now. And I think the US Olympic Paralympic Committee, when they had these major issues come up, they said, well, let's do something similar with sexual misconduct cases and create this safe sport in the US Center for Safe Sport, which was really modeled after what they did in anti-doping with USADA. And that's what they did. And it's taken a long time. There's a lot of growing pains. There's certainly a lot of things that safe sport could do better. I've heard people suggest that the whole thing is set up like as a whitewash, so that the Olympic movement doesn't have to deal with sexual misconduct cases or can sweep them under the rug. I don't believe that. honestly. I mean, I don't think that that was the purpose of creating it. And, you know, if you talk to the people at Safe Sport, I think they're pretty serious about cleaning it up and policing this area. I think a lot of the people that have the broad kind of outrageous criticisms of Safe Sport have no involvement. They've never handled a Safe Sport case. They've never gone to a Safe Sport arbitration. And most of them have a very profitable law practice, which is threatened by Safe Sport because they're representing people suing national governing bodies for sexual misconduct. And if Safe Sport is successful, maybe there's no need for them anymore. So I think they have a conflict when they're criticizing them. But, you know, we've been involved in the Safe Sport cases from the beginning. I was, to be honest, I mean, I was not really even sure I wanted to do the work. We got involved in some of the early cases, and I think of the cases that have gone to arbitration on the merits, we've done maybe over 80% of them, you know, 80, 90% of them. We've handled 50 plus Safe Sport cases in the last 4 years, including cases that are open now. And, you know, we usually feel like Safe Sport is overly like believe the victim, believe the accuser mentality, that they're overly harsh against the accused. And then there's other people that say the exact opposite, and the truth probably is somewhere in between. For a long time, they definitely needed more resources, no question. They have those resources now, and I'll be curious to see how they're utilized. You know, they have a huge case backlog. It does affect the investigations. It affects their process. And, you know, they need to hire more people. They need to clear up the backlog. They probably, in a lot of cases, need to do more thorough investigations, do more timely investigations. And then, you know, the process, of course, it can be improved. But I think most people, reasonable people, would agree that the goal and the aim is a legitimate and needed goal and aim.
And does the USOPC have some sort of control or leadership over the Center for Safe Sport, or are they totally separate?
They're totally separate. The only thing, I mean, it's interesting. Congress makes the USOPC pay, I think it's now, what is it, $20 million a year? It was $7 million or $7.5 million a year that USOPC was funding Safe Sport before the new legislation, and now Congress says, well, you have to give them $20 million a year, which is odd, honestly, from where I'm sitting. Like if Congress thinks that they need more money, Congress should give them more money. It's strange to me for Congress to say, we're not going to give you any money, but you, the USOPC, this private, you know, it's not a governmental entity, you have to give them X dollars. We're going to tell you how much you have to pay them. But that's what they've done, and that's where it is. But the U.S. Center for Safe Sport they're not under the control of the USOPC. They don't report to them. They have an independent board, independent people.
And are there cases actually heard before the Center for Safe Sport? So, for example, if an athlete comes to you and says, you know, my coach has been assaulting me since I was a kid. You go to what do you have to do to get into Safe Sport or before Safe Sport?
So, I mean, we're usually on the other side. We have done both sides. I mean, we've represented people filing claims, or we've represented witnesses before Safe Sport. The majority of what we do is defending the people that are accused. But if somebody has a complaint, you know, they can file a claim with the U.S. Center for Safe Sport. They can do it anonymously. They can do it with their name. Safe Sport ultimately will decide whether they're going to investigate it. I would say the majority of the cases, they do investigate. They assign an investigator. That investigator does an investigation, ultimately writes a report, submits it to the leadership of the U.S. Center for Safe Sport, and then they issue a decision. You know, they say, we believe that you've violated the code, and they impose a penalty. Just yesterday, that, you know, the big news was Salazar, right? Alberto Salazar they issued a notice of decision banning him for life. And so that's the safe sport process, the investigation process. They have an investigation. The accused can participate in that investigation or not. It's the accused's choice. And then if a penalty is imposed, then if the person that has been sanctioned doesn't agree, they say, I didn't violate the code, or I violated the code, but your sanction is insanely excessive, or even just excessive, then there's an arbitration system. And they have the right to request arbitration. They get an arbitration before an independent arbitrator administered by JAMS. Very good arbitrators, a lot of retired judges. They're not in Safe Sports pocket. And those arbitrations are really fair. I mean, we've done close to 30 of them now. And, you know, those arbitrators, they take it seriously, and they hold Safe Sport to their burden of proof, as they should. It's a lower burden of proof than you would have in a criminal case, but they still have the burden of proof. They still have to prove their case. And if they don't, then the arbitrator will vacate the sanction. We've had that happen in probably a third of the cases that we've gone to arbitration. The arbitrator said, Safe Sport, you didn't prove it, so the sanction's vacated. Or the arbitrator can say, well, we agree that there's a violation, or but the sanction's too long. Because the arbitrator, ultimately, if they find that there's a violation, the arbitrator decides if the penalty that was imposed is appropriate or inappropriate. And so in another third of the cases we've had where the arbitrator has said, you know, okay, I do uphold the violation, but I think that your sanction's too long. And so in quite a few cases, the arbitrators reduced it. But you get a fairly robust arbitration system, very much like any other arbitration, you know, administered like a commercial arbitration. You put on witnesses, you've got opening statements, closing arguments. And so both sides have the opportunity to participate, and there's protections built into the rules for, you know, for victims who either don't want to answer questions from the lawyers. They don't have to. They can say, I'll only answer questions from the arbitrator, and then both sides submit questions to the arbitrator. Or they can, if it's a minor and they don't want to do it in the presence of the person that they say assaulted them, then there's protections built right into the rules. And so I think that, you know, there's certainly an attempt to balance the interests of both sides, but to also have a system that's fair to both sides.
I know that personally I've had to take the Safe Sport training for coaching youth sports. Is it a requirement to bring someone before Safe Sport that they've gone through the Safe Sport training program?
No, it's just a requirement that they were a member of an NGB at the time of the conduct, or they're currently a member of an NGB or seeking to be a member of an NGB, just to simplify it. And a number of sports, you can't renew, you know, now Safe Sport's been going on for a while. So your membership renewal comes up and they say, well, you can't renew until you do the Safe Sport training like you've had as a coach, or, you know, you got to do the background screening, you know, these things that didn't exist in the past. So ultimately, it'll be hopefully that most people, if not everyone, has had it.
Yeah, well, I mean, I know it reminded me of the sexual harassment training I used to have to take in a corporate gig. And I know every 2 or 3 years when I'm getting ready to sign up and I go to USA Rugby and they say, oh, you need to renew your Safe Sport certification. So then it's a few hours going through that, but it's a good system. I know we're running out of time. We've pushed it, but I've just got to ask you something real quickly. And there's other parts of your practice I'd love to get into, but we have the Olympics going. If somebody during the Olympics gets a positive test, are you jumping on a plane and flying to Tokyo to do a CAS arbitration, or how does that work?
Well, nobody's jumping on a plane these days, but and in a lot of ways that makes it easier. It used to be, you know, you had to jump on a plane. Now I think we'd be doing an arbitration in the middle of the night by Zoom. So if that happens, we'll do it. If there's a protest issue that an athlete gets sanctioned by the IOC, because the USOPC has said we're not going to sanction anybody that protests. The IOC hasn't taken that position. Those issues are bound to come up, and those could end up at the Court of Arbitration for Sport as well. So yeah, we're here, we're arbitrating, and we'll, any time of day or night.
Well, I think it's interesting that with this distinction in Rule 50 between, what the USOPC has said and what the IOC is saying, and yet we've already seen one match where the two women's teams took a knee before the game. Nothing happened. Now, I guess we'll wait and see if somebody gets on a medal stand and does something.
Yeah,
but it'll be interesting.
That seems to be the bright line that they've drawn, is they don't want Tommy Smith and John Carlos redone at the Tokyo Games. They don't want another iconic image, I guess, but somebody's going to do it.
I think so, and you know what? We'll just see what the IOC does and what the pushback is, but it's an interesting and unique Olympic Games. So whatever's going to happen will be, I think, sui generis. No crowds, no people, different vibe. But there's a lot of things going on and more cases for your firm. So Howard, thank you so much for taking the time to speak with us. Really appreciate it. It was really interesting stuff. And thank all of you for tuning in. Remember, for information about the Sports Lawyers Association, go to sportslaw.org, become a member. Lots of great things ahead. Besides these sorts of events that we do bi-weekly, Sports Shorts, we have podcasts, webinars, and of course, our annual conference, which, all things being equal and all things being good and no more variance, we'll see you all next spring in Atlanta. So thanks, Howard. Great seeing you.
Thanks, Bobby.
Good luck with your practice and everything. And you can go out for your bike ride now.
Thanks.
Thanks. Bye, everybody.